in the matter big title, not Joanne. Oh. I've started without her on occasion. All right. No, this is the other people. All right. This is in the matter of Troy McLaughlin, an individual plaintiff, and Gail White, an individual intervening plaintiff, versus Stephen Barnstable, an individual, Teebs LLC, a Michigan limited liability company doing business as Teebs of Adrian, and Barnstable Realty LLC, a Michigan limited liability company, file number 2022-6888CB. I have G. Will Furtado, P77848, appearing on behalf of the plaintiff. I have W. Daniel Troika, P65155, appearing on behalf of the intervening plaintiff. I have Jacob L. Carlton, P84859, appearing on behalf of defendants, and Ms. Subley is no longer involved, right?
Correct, Your Honor.
Okay. I also, and Mr. Troika and Mr. Carlton are via Zoom. So, are you ready to proceed, counsel?
Yes, Your Honor.
So it's my understanding, the discovery motions, we had a motion to extend discovery, motion for production of documents. There was another one that was mentioned that we didn't even have on the calendar. Those have been dismissed, and we are continuing today on the motion for summary disposition.
Correct, Your Honor.
As well. Yes, Your Honor.
And Your Honor, if I may just make a point, I represent Gail White. We submitted a consent judgment that resolves our matter. I believe it was entered by the court. I've not yet received the version as entered by the court. I'm here just in case, but I do believe our matter is wrapped up.
I think so, but I don't have that at hand just because today's filings are the only file I have because we're on 3 of 3. So do you agree with that?
Yes, Your Honor. We withdrew our objection to consent judgment.
And Mr. Carlton?
Yes, Your Honor. The court's online docket indicates that the court entered the order. I haven't seen a copy of it either, but that was a final order that resolved the intervening complaint.
So I'm assuming it's making its way back to you, Mr. Troika.
Thank you.
All right, thank you. All right, so Mr. Carlton, this is your motion, right?
Your Honor, plaintiff has 3 remaining claims. One of them is for a common law statutory partnership. One of them is for promissory estoppel, and the third is for unjust enrichment. I'll keep it brief. The partnership claim under the statute, the partnership statute, requires that the parties acted as co-owners of a business for profit, and that's MCL 449.6. Under the Biker v. Manns case, which is the Michigan Supreme Court case dealing with this statute, the court says to go and look at the actual acts and conduct of the parties. And here, the acts and conduct of the parties are simple. The plaintiff in his deposition has admitted he never received any portion of the profits of Teebs LLC. He admitted in his deposition that he is not a member of Teebs LLC. He admitted in his deposition that he fully understood that more documents were necessary to complete the relationship. He admitted in his deposition that he did not put any money into Teebs LLC. He admitted in his deposition that he was not pre-qualified to run a marijuana business at the time. He admitted in his deposition that he was paid as an independent contractor. He admitted in his deposition that he never objected to him being paid as an independent contractor. And he admits that he was unilaterally fired by Steve Barnstable from the entity. And so, Your Honor, based on these admissions from the plaintiff at his deposition, the plaintiff cannot establish that he was an owner of a co-owner of a business for profit. He was treated as an independent contractor. There's no dispute that Teebs and the plaintiff hoped to get to a point where they would create a new LLC together in which they were sharing 50-50. That was part of the Adrian agreement. We don't dispute that. But one of the lines of the Adrian agreement states that if this new entity is formed, Stephen Barnstable would continue to act as overall managing member and director of operations for the business and would be responsible for all aspects of business operations. When came time for the parties to actually enter into a new operating agreement, which shows how the new company would work together, Troy McLaughlin would not agree to a term that would state that. I asked him at his deposition, so if Steve proposed an operating agreement for Teebs Adrian LLC to you that made him the managing member and director of operations and gave him sole day-to-day control of the company, would you have agreed to that? His answer, and this is on page 50 of the deposition transcripts, line 18 to 2020, I don't believe I would have. And so what you have here, Your Honor, is a case where two people hoped to be in business together in the future, but they could never come up with an agreement on how that would look. But they never actually acted as co-owners of a business for profit, which was required to satisfy the statutory partnership statute. And I'll also like to point out, Your Honor, that Troy McLaughlin during this time period was not qualified by the state of Michigan to operate a marijuana company, which means as a matter of law, he could not have been an owner of this company during this time period because he was not pre-qualified by the state. And the state requires all owners, anybody who has a 10% or greater interest in a marijuana company, to be pre-qualified by the state. As for the unjust enrichment claim, unjust enrichment has two elements. One, the receipt of a benefit, and two, an inequity based on the retention of that benefit. It's not entirely clear what he claims the benefit is that was bestowed upon Teebs. The brief mentions two things. One is the license, but to go back, Your Honor, what happened is, and nobody disputes this, Troy McLaughlin was in line to get a license. He backed out of line, and Your Honor, and eventually Teebs got the license from the city of Adrian. Now, Troy admitted in his deposition that there was no document that says Troy must back out of line. There was never a contractual document that Troy must get out of line. But I would also like to point out, Your Honor, Adrian Municipal Code 46-505C1, which we cite in our brief, states that a local applicant, somebody who's applying to the city of Adrian to obtain a local license, must show that they have approved pre-qualification status from the state of Michigan, and that failure to have that status is grounds for denial of the application. That is the local rules in the City of Adrian Municipal Code that says to obtain a local license, you must be pre-qualified. And there is no dispute, Your Honor, at this time that Mr. McLaughlin was not pre-qualified by the state of Michigan. He could not have operated an entity until he obtained pre-qualification status, and his application for a local license would have been denied because he was not pre-qualified. The next alleged benefit he claims is that during this time when Teebs was getting started up, it was that he was working for Teebs and should have been paid. As we cite the deposition transcripts, on page 69 of the deposition, starting on line 16 through page 70 of the deposition through line 8, I asked, you were willing to accept $1,000 a week for what you were doing? His answer, correct. Did you ever reject any payment? Answer, no, not that I can recall. So from the time you were working there, from May of 2021 through September of 2021, you accepted the $1,000 a week, correct. Question, did you ever in writing dispute the amount you were getting paid? Answer, no, not in writing. So for the work that Mr. McLaughlin performed for Teebs during this time when he was not pre-qualified, Mr. McLaughlin was paid as an independent contractor and never objected to that payment. And finally, Your Honor, the second element of an unjust enrichment claim is the retention of a benefit that would be inequitable to retain. And so the question here is, what benefit has been inequitably retained by Teebs LLC or any of the defendants? Teebs has failed There has been multiple lawsuits against Teebs in this case, Mr. Troika's complaint, Ms. Subley's complaint, because Teebs failed. It doesn't have enough money to pay the people it owes money to. It has a, apologize, Your Honor.
It's okay, and I'm gonna let you know we only have till 12. So I've read the brief and I've read the responses. So Mr. Troika is going to need to respond as well too. So
now briefly touch on the third point, which is the estoppel claim. The court has already ruled that the Adrian agreement is not a clear document to be enforceable. And based off that ruling, Your Honor, and if you read the Sixth Circuit cases we cite in our reply brief, it cannot be used to establish a clear and definite promise if the court has already ruled that it's an unenforceable agreement to agree. And finally, Your Honor, the last point I would make out, even if the court doesn't grant the request to dismiss all three claims, the court should dismiss Barnstable Realty LLC and Stephen Barnstable personally. The Adrian agreement was entered into between Teebs LLC and plaintiff Troy McLaughlin. There's no basis to bring any claim against a real estate holding company or Steve Barnstable personally on any of these claims when the agreement was to form a company between Teebs and Mr. McLaughlin, not Mr. Barnstable personally and not Barnstable Realty personally. So unless the court has any questions, I will let Mr. McLaughlin go ahead.
okay, response.
Thank you, Your Honor.
Could you stand at the podium?
Yes.
I know you got your notes, but
No,
just so we get good
I
audio.
appreciate that. If you can bear with me. I know Your Honor has read the briefs. I have to ask, has Your Honor had an opportunity to listen to the recording that was provided with plaintiff's response?
No.
There is an hour-long recording between Troy McLaughlin and Steve Barnstable from December 2020, 3 weeks before the store opened up, where Steve Barnstable talks about paying Troy in draws. He talks about what access to records Troy is going to be provided. He talks about how they're both going to split the remaining profits of the store 50-50, half. He talks about Troy getting paid $100,000 in draws, and how if anything wasn't paid as a draw because the store wasn't profitable, it would accrue to be paid later. I highly suggest before the court rule on this that it listen to that recording and that it read Gail White's affidavit that's been attached to the pleadings and notarized. This case is replete with evidence that Steve Barnstable and Troy McLaughlin carried on as co-owners of Teebs of Adrian for a profit. The partnership here, and to his credit, Mr. Carlton does his best to try to confuse the court. The partnership here is not Teebs LLC. It's very clear in the pleading that the allegation is that a partnership is formed with Troy, with Steve, and with Teebs LLC as a partner. Nothing prevents Teebs LLC, the fact that it is an LLC, from being a partner in a partnership. I think it is interesting that Mr. Carlton has relied so heavily on the Adrian agreement to say that that forecloses claims against Steve Barnstable, because this court has ruled that was not an enforceable contract. It's an agreement to agree. It is certainly indicative and it is evidence of the promises that Stephen Barnstable made to Troy McLaughlin. With respect to unjust enrichment, again, Gail White's affidavit, Troy's deposition testimony was that he provided benefits to Barnstable Realty, which was the owner of the building. He actually physically performed improvements at the building. He negotiated the plaza agreement that was entered into by Barnstable Realty. He negotiated the purchase of the Hungry Howie's property by Barnstable Realty. These were all actions that Steve took on behalf.
Hold on, Mr. Barnstable, I'm going to mute you because you're not muted. So hold on. All right.
I'm sorry, ma'am.
I'm muted. It's okay. Go ahead and mute yourself.
Yes, ma'am. I'm sorry. Very sorry.
Okay, go ahead.
He performed all of that for Barnstable Realty. And then when the store got licensed and opened in January, he performed services for Teebs LLC. And I think it is interesting because Mr. Carlton says the promise was that Steve would pay Troy $1,000 a week. He started paying him in May of 2021, and he stopped paying him in September of 2021 when he fired him. Troy wasn't paid anything for the year he spent prepping the building, prepping the business to get licensed and go into business. He wasn't paid anything for his first 4 months as a general manager from January through April 2021. And in fact, despite the promise, which again, I implore the court to listen to the recording of Steve Barnstable and Troy McLaughlin from December 2020, he promised Troy that he would get paid draws, and anything that couldn't be paid as a draw because of lack of profits would accrue. What did he do? He told Troy there were no profits, there are no profits, there are no profits, there are no profits. And when Troy says, I got to get paid something, I'm living on credit cards, Steve says, all right, I'll pay you $1,000 a week. In the meantime, secretly, I'm going to pay myself $3,000 a week as salary, because Stephen Barnstable testified in his deposition he paid himself over $150,000 in salary from the company, this beginning when he started paying Troy as an independent contractor. And Troy testified that that decision to be an independent contractor was Steve Barnstable's decision, not Troy's. When he was asked if he thought he gave up any rights to profits or member distributions by entering into that or accepting that, he said no. And in fact, after this case was filed, Steve Barnstable sent Troy a K-1 for 2021 that identified Troy as a 50% partner and allocated $193,000 in partnership profits to Troy. How we can be here with Mr. Carlton and Mr. Barnstable representing that there was no promise of a partnership, they didn't carry on as owners of a partnership, there was no promise to be 50% members, there was no unjust enrichment, is absolutely beyond all of the evidence in this case. This case needs to go to trial. A jury needs to hear these claims, and it needs to hold Steve Barnstable and the defendants liable for their lies and their misactions. If the court has any other questions, I'm happy to answer them.
Thank you. All right, Mr. Carlton.
Thank you, Your Honor. We don't.
Trika, you're just watching now, right? Okay, just making sure. Mr. Carlton.
Your Honor, we don't dispute the conversations that were had that were apparently recorded by Mr. McLaughlin secretly. We don't dispute that those conversations occurred. We don't dispute that there was an intent to get to an agreement where they could operate a new company together, but the parties could never agree on what that would look like. The sole line from the Adrian agreement that shows what the relationship would look like states that Mr. Barnstable would remain in charge. But Mr. McLaughlin refused to enter into an agreement that contained that. His deposition on that is clear. He would not agree to sign an operating agreement that would leave Mr. Barnstable in charge, which is one of the few points in the Adrian agreement. Mr. Barnstable would remain in charge. We don't dispute we had conversations where we talked about the future, what the future would look like, but the parties never got there. And again, Your Honor, I would remind the court that as a matter of law, because he was not pre-qualified by the state of Michigan, he could not, as a matter of law, been an owner during these times. Thank you, Your Honor.
All right, thank you.
Your Honor, may I make one just response briefly? On the pre-qualification, the city council records are clear that Troy McLaughlin was granted a conditional permit for his property, and it was then rescinded with reference in the city council minutes in July 2021. Troy received a conditional permit, regardless of being pre-qualified. Tamaris Hennigan, who was the city attorney at the time, is on our witness list and will testify that he was issued a conditional permit despite not being pre-qualified. And with respect to the pre-qualification question, I will forgive Mr. Carlton as he might not be familiar with how the process works. But in Michigan, when you go to the CRA, the state level, to amend a license and add another owner who's over 10%, you do that through what's called a supplemental individual pre-qualification application that goes along with the amendment. You don't have to go get pre-qualified before, then execute the documents and say you're a 50-50 member, then go to the CRA. The pre-qualification comes as part of the amendment to the CRA. Thank you.
All right, very good. I'm going to take this under advisement and I will issue an opinion.
Thank you, Your Honor.
I'll find some way to listen to that because I'm not allowed to put anything in my laptops. They like suspend my, I don't know.
So I'm sorry, if we're off the record, I'll ask the question. I just